So this is the meeting, the March 25th meeting of the Planning Policy Commission. We are having a joint meeting this evening with the Economic Vitality Commission. So please welcome. We're glad to see you and having you part of this discussion. There's a few things that we have to go over first before we get into introductions. So I'd like to take care of that before we do anything else. Because of the governor's proclamation, this meeting is being held entirely remotely. When you have a question for all your commissioners, use the chat and put in question or comment, and you will be called upon in the order that they go in. We are not going to have approval of minutes tonight, but we are going to have Kristen do a roll call of the Planning Policy Commission.
Okay, Commissioner Fall.
Here.
Commissioner Carl.
Here.
Commissioner Voice.
Here.
Commissioner Monahan.
Here.
Commissioner Milligan.
Here.
Commissioner Zaragoza.
Here.
And Commissioner Lewis.
Here.
And Chair Probola.
Here. So with that, I would like to call on Jen Davis to introduce herself and to introduce her commission.
Great. Thank you, Chair Probola. My name is Jen Davis Hayes, and I am the Economic Development Manager for the city, and I staff the Economic Vitality Commission. And this is a meeting tonight. We actually have new members on board, so thank you for allowing us to at least introduce each other. So I'll do the roll call with Vice Chair Commissioner Baudouin.
Here.
Commissioner Edwards.
Here.
Commissioner Brown. I did see him.
His here.
Okay, thank you.
I'm right here.
Commissioner Kassler.
Here.
Commissioner McCrory.
Here.
Commissioner Remy.
Here.
Commissioner Freeze.
Here.
Commissioner Reichley. Chris. Here, okay. Commissioner Ashwin. And I'm not going to try to do your last name. Sorry, sir.
I'm here.
Yeah, it's okay. Commissioner Rogers. I don't believe he's here yet. And Chair Garcia. She did say she was going to be about 10 or 15 minutes late. And we do have one commissioner who is excused, Commissioner Probola, who is actually serving as the chair of the PPC. And so we will have our alternates sit in that seat if we have any votes tonight. So I don't believe that we have any, though. Thank you.
No, we do not have any votes. This is strictly a conversation this evening, but I am going to call on Kristen to introduce any staff that's present.
Hopefully I don't miss anyone here. We have quite a few. So we have Lucy Sloman, our Land Development Manager, who's going to be giving our presentation tonight. We have Andrea Snyder, our Deputy City Administrator. Jen Davis Hayes, our Economic Development Manager. I believe that Dan Martinez and Holly Keaton, both planners with the Community Development Services, Community Planning and Development Department, are here, excuse me. Ben Koblenz also with the Economic Development, and we have I'm Kristen Leeson, Senior Planner with Community Planning and Development, and last but certainly not least, we have our brand new Community Planning and Development Director, Minnie Dollywall, here with us tonight, who will hopefully speak a little later. Thank you. Oh, one more thing before I leave, I apologize. Welcome, by the way, Minnie. One more thing before I leave, just to be clear for newer members, and when you have a question or comment, and Joan already said this, but don't actually type the question or the comment, just put the word question or comment. Yeah. We want to make sure that the conversation is had publicly and not in writing. Thank you.
This evening, we're going to be talking about the sign code, and we're going to run our meeting just a little bit differently than normal. I want to set out the parameters of how it's going to happen so you kind of know what's going to happen. Lucy Sloman is going to present this evening, and she's going to walk us through all of the areas of the sign code. We are not here to rewrite the sign code. We are just here to offer our suggestions on some of the upgrades that have been made, but mainly to answer some questions that the city has asked us. We have never been in a position where we have been asked to do actually what we're doing tonight. Normally, the city brings their draft proposal to us and we work on the proposal. Tonight, they are actually asking us to give them our input before they actually make the final draft. And so we have a special things going on this evening. But how it's going to work, Lucy is going to give going through the list of all of the areas I think there's 14 areas of the sign code. After that, and during the time that she's presenting, the commissioners can ask questions or offer comments so that we can get each area thoroughly discussed. Then I'm going to open it up to public comment. And after public comment, then we're going to go back. In your packet, there's a list of 5 or 6 questions that the city has asked us to look into, and we're going to go through each one of those questions. I will lead basically that discussion, and then if there is anybody in the audience, we will open it up for public comment again before we come back to make final decisions, discussion of the sign code. So I think you all understand that, right? So there will be 2 public comment periods. I did forget to mention that since we are going to have public comments, anybody who wants to make a comment, the information is in the agenda and online. And if you want to speak, hit *3. You have 5 minutes to make your comments. After you make your comments, please turn off and make yourself mute again so that we can go on. With that, I am going to introduce our fantastic land development manager, Lucy Sloman, and have her start our presentation for the evening.
Good evening. Let me share my screen. Is my screen showing?
It's showing, but there you go.
That's better.
Okay, not starting from the correct slide. Just give me a moment.
Lucy, you would want to go to display settings as well because we're seeing and switch your display settings. There you go.
Tell me what that, you said there you go.
We were seeing your slide plus your notes or any notes that would have been there. And now we're just seeing your working screen. It's not on the slide screen yet.
Does that mean you're seeing the right thing, Kristen?
Yes.
Okay, great. Thank you, because from what I can't tell which of my many screens is the correct one, so my apologies. Good evening. Lucy Sloman, Land Development Manager. So tonight is the first step in our sign code update. We have had several preliminary meetings with different commissions, including 2 with PPC and 2 with EVC, or 1 with EVC. But now we're starting a process with a draft, as Chair Provola mentioned. What we brought to you tonight is what we call a discussion draft. This, as you may have noticed, has lots of highlights and red comments because there were many questions that we really wanted community input before we prepared our draft for the public hearing. There are 2 sort of big components to the presentation tonight. After my introduction, we will do an overview of the changes, and we will focus on the 5 discussion topics that were included in your memo. These are on non-commercial signs, old town signs, the kiosks, flags, and landmark signs. As was mentioned, if after each of the topics, I will pause and ask if commissioners have questions or comments. Use the chat as mentioned. Public will have 2 comment periods, or you are welcome to email me. My email will be up this evening. So I'm going to begin with a couple of background slides on background and goals. The first piece I want to address is a U.S. Supreme Court case that was handed down in 2015 called Reed versus the Town of Gilbert, Arizona, or Reed v. Gilbert for short. This directly impacted content-based regulations, meaning that we can no longer, if we have to read a sign to know what regulations apply, then we do not have the right regulations. This is primarily affecting non-commercial signs. In the images at the bottom of the slides on the left are the images on the left, the event signs, ideological signs, and election signs. Those are examples of non-commercial signs. In fact, the event sign shown was the sign that caused the Supreme Court case. That was the genesis of it. And because it's a U.S. Supreme Court case, it applied across the United States and required many communities to update their sign code. So one of our goals is to comply with the Supreme Court case and any other legal changes taken place since then. The image on the lower right is an example of commercial signs. That's what I think most of us think of when we think of sign codes, is the signs that are placed for businesses. But in this case, the Supreme Court case was not dealing with that. Second piece of background is that in the city of Issaquah, we have 3 sign codes right now. We have what is called IMC 1811. IMC stands for Issaquah Municipal Code, and 1811 is the chapter. That was adopted in 1998 and is about 34 pages long. Central Issaquah Development and Design Standards, more commonly written as CIDDS, but sometimes just called Central Issaquah Standards, was adopted in 2013, and then in 2018 expanded to cover Issaquah Highlands and Tallis. The reason I mention the pages, such as 34 pages or 50 pages, is just to give you a sense of how extensive sign codes are. The Old Town design standards are not primarily sign standards, but they do have 3 pages on sign design, and they were adopted in 2001. So our goals are to consolidate all these various codes into a single document that will cover the entire city except those areas that have development agreements. We have about 5 development agreements. And make our rules consistent, while also recognizing that there are parts of the city that may need to have unique standards to maintain their character. Our third and last background and set of goals is related to the work that staff has been doing with council related to Title 18. Title 18 is a portion of the Issaquah Municipal Code related to land use. And beginning that process, which we're going to really dive into later this year, staff worked with council on a set of goals and outcomes. Goal and outcome number 12 relates to signs, and it had primarily four components: addressing Reed v. Gilbert, making sure that the I-90 corridor complies with state law and the Mountains to Sound, or M2S, vision, making the code easier for businesses to use, and making it so residents don't notice a significant change as we do this update. So what we've really looked at, our goal was to streamline, and we're doing that both in looking at the code in terms of what would be regulated, collecting variations of signs into a single type, while maintaining the options. So we've tried to really pare it back without reducing options. And in terms of process, we've tried to create a consistent process across the city, and where decisions aren't discretionary, allow staff to make those decisions, and where they are discretionary, have the council make the decision and commission make the decision. So now that I've concluded my introduction, I'm going to give you the overview, a couple of notes about that. I'm going to quickly review each of the sections and the changes that were made to them. Commissioners, at the end of each of these, I will stop to give commissioners an opportunity to comment on that section. You're not limited to commenting just on the changes that I've identified. You're welcome to comment on any aspect that you think should be noted, and use chat as has been described. Public will be able to comment at the end, but you're also welcome to email comments to me. My email appears on each slide, and if it's easier or you get impatient, please feel free to email me. Also, if you see little errors, typos, grammatical errors, format problems, please email those as well. We have a lot of material to cover this evening and won't really have time to cover that. So then once we finish the overview, we will go into more depth on the 5 discussion topics that were included in your memo. So here we go. First section is purpose. The purpose statements set the stage for everything that follows. Generally, the ones that we've included are a blend of Central Issaquah and IMC 1811. While it may seem like this is kind of fluffy and just words, I will tell you that staff uses these a lot when we have to do adjustments of standards or interpretations. And so they are important in terms of setting the stage and give us a framework, a big picture view of what we're trying to accomplish. Any comments from the commissioners?
Nope. Not at this time.
Okay. Thank you. I can't see the chat box, so just so you know.
Oh, then I will inform you if there is one. Okay.
Perfect. Thank you. Next section, applicability. This is generally new text, and partly it just describes what the code will be what the code applies to, but it also sets the stage for commercial versus non-commercial signage. Any comments from commissioners?
Nope. Just continue on, and I will interrupt you if there is one.
Well, I want to also give them a pause. They may not be as quick on the typing at the chat. So definitions. Generally, there are a lot of definitions in the sign code. It's a significant part of the text. And these are primarily drawn from Central Issaquah and IMC 1811. Many of them match between Central Issaquah and 1811. But we also have added some where we believe that we needed some new ones due to changes in the code, or new kinds of signs or situations that have come into our community. We also have occasionally pulled definitions from the Raleigh Development Agreement. Those show up as Raleigh DA. And we did that where we thought a definition better suited a situation or where we had a previously undefined term. About 60 definitions were removed. We removed definitions that were listed in our general definitions section, 1802, where text was deleted or consolidated. And we also have taken the approach that cross references are not going to be left in. And an example of that would be the current sign codes have box sign defined, and it says see cabinet sign. And when you go to cabinet, now when you go to cabinet sign, it will just give you the definition of a cabinet sign and then say also known as box sign. So many people are using the codes electronically that kind of searching makes it easier and significantly shortens the sign code. Any comments?
I have a question from Commissioner Lewis.
Thank you, Chair Provola. Commissioner Joy Lewis here. I was curious, Lucy, if you guys had discussions about defining non-compliant. We have non-conforming, which is an entirely different category. And I'm curious if there was, if it had been purposely ruled out to actually define what a non-compliant sign is.
Commissioner Lewis, could you tell me, I would say we have not had that discussion. I'm interested if you could tell us a little bit more about it, and we'll look into that with the next draft.
The classification of saying whether a sign has lapsed from its permitted date, whether it doesn't match what was permitted. I don't know if there's a classification for basically what is not adhering to the code, and then kind of how that gets designated and then those next steps. And so if it's worth having a definition for it, I'm not sure. But I did notice that wasn't addressed, and I wasn't sure if it was on purpose or not.
Haven't discussed that before, so great. We'll look
Thanks.
into that. Thank you.
Thanks, Lucy.
So I have a comment from Commissioner Matt, and I don't have his last name, so I apologize.
No worries. Thanks, Chair Provola. I had a comment on the definition of open house. It's currently defined as the welcoming of viewers to a piece of residential real estate which is being offered for sale. This might just be my layperson's understanding, but I thought open houses happen on designated days. And I thought there should be some incorporation of that concept, given, if I'm reading the sign code correctly, they get, you get to put out a lot more signs to advertise an open house, which makes sense. But I wouldn't want them to have some kind of loophole where they could leave them out all the time by saying, oh, it's an open house every day. That's usually not the case.
Great, thank you. I've made a note and we'll look into that. Thank you.
Thank you.
Any more?
No.
Okay, thank you. So we have a new section in the code called exempt from sign regulations. While the section is new, it does consolidate several elements that are present in Central Issaquah or IMC 1811. And it basically has 5 components. The first is signs that are required by government. For instance, address signs are required by the fire code, or land use notice signs for public hearings. Those are required by a code. And so this would say that we don't have to provide exemption or put them into the accepted sign permits. We can just rule out that class. Second are government signs for health, safety, and welfare, such as the sign shown in the lower right. Those kinds of warning signs, safety signs are exempted. We are not providing a general exemption for government signs. For instance, if the city had a city hall or a park, the school district has a school building or there's a fire station, they would need to follow the provisions of the sign code. But the health, safety, welfare signs would not. The third category is art. We had some text in the existing sign codes that talked about art. Art is not a sign. But I do want to talk about that a little bit relative to logos versus something, for instance, like holiday decorations. The sign in the lower left-hand corner, those two banners on a pole, those could, if they were the logo of a shopping center, those would be regulated as a sign. However, if they are just art celebrating a summer season, for instance, they would not be regulated as signs. Holiday decorations were specifically exempted from our code. Those are not signs. So we've tried to clarify through this particular provision things that are not signs are and are just there for artistic reasons are not regulated. Signs not visible to the public. We have had provisions in the sign code for a long time saying that if it's not visible to the public from public spaces, that it's not regulated, but we wanted to put that up front. The fifth category is vehicles. I know that we've received a comment from the public about this, and so I want to speak a little bit about this. Vehicles that are driving down the road, that are parked in front of a customer's, are parked in a parking space in front of the business. That's the intent of this particular provision, is to exempt them from sign regulations. However, we have in the city seen businesses using their vehicles, parking them not in regular parking stalls, but placing them to give themselves an additional sign. So for instance, if you have a parking lot in front of your business and you place your van crossways across head-in parking so that to ensure that the side of your van is visible to everyone driving by, that is a concern because it's giving you an extra sign beyond those regulated by the sign code. Any questions?
Yes, I have several. First of all, we have a comment from Commissioner Lewis. Or is it a question?
Thank you, Chair Provola, Commissioner Joy Lewis. I was hoping, Lucy, that you can give us a little bit more about art that isn't a sign. I think this one can get a little bit tricky. And I'm going to use a concrete example of a beloved piece of art in our city, and that's at the dairy. So, you know, when you start using, for instance, a vintage logo that maybe isn't currently in place, but is of a business. Obviously, the images of cows and milk evoke the functioning dairy transfer station that is there. And I was curious where the city, because I think it's a good place to start as far as like something that I think could go into either or. And I think it's interesting to start kind of discussing how we kind of piece that apart, since art often does imitate the life that it's around it. Pictures of children on a school mural. I mean, you know, it starts to get a little bit iffy, right? So I was hoping that you could have a little bit more of a conversation about specifics in our community for this.
Sure, and I love how you started with a really easy example, Joy. But you're right. It is a challenge that we face with murals in particular. We also have had that question when Top Pot Donuts came in. They wanted to put in a large donut. And those kinds of symbols related to a company are considered a sign. And so it does become tricky with certain kinds of businesses, such as Swedish Hospital. They had put images in their windows of healthy people out enjoying life, and there was a discussion about where that crossed the line. So I think it is a great topic, and we have been talking with Daniel Kenny, who is our legal counsel and co-author for the sign code, to help us try and figure out those edges. And I think if you have more, partly we're relying on the definition of signs, which is number 75 on page 21, if you're looking at your packet. But I think we're also looking for guidance and feedback from the commissioners.
So I think to be more concrete, to try to help the discussion, does the fact that it's a currently used logo make a difference, for instance, with the city, right? If it's from another bygone era, does that then classify more as art than it does necessarily as advertising? And when generic symbols like a like a donut or a cow are used, pastoral images, and I want to say these are beloved things in our community that are, how do we best protect them, I think is a good example, and allow them to flourish throughout the city. I think is something else that we need to think about with our sign code, right? How do we enable rather than necessarily just kind of put everything into boxes? So kind of where does that line come as far as more generic images? I think is something that's interesting to see. Where does staff fall on, rather than a current logo, for instance? I see a difference between them. I'm not sure if staff does.
Well, I think to the point that I believe I'm hearing, unlike some other communities that have more older buildings with some of those historic logos for businesses that aren't in place, I agree, and I think we would be supportive of allowing that history to be retained when it isn't directly related to a business that it is active. I think it is a little trickier when we get into these representations. What is the difference between a symbol for that has become so closely associated that even though it's not a word, it is effectively a logo. So again, I don't think we're trying to be definitive at this point. I'm hearing the concern, and I think that's one that we will continue to work on and bring back a response with the public hearing draft.
Thank you, Lucy.
I have a question from Commissioner McCrory.
Thank you. So, Lucy, my question is about when you meld the art and the logos on a banner. And we have seen many times on the street banners, especially lately, where street banners are paid for by businesses and their logo is attached to that as a promise to trade the dollars for helping purchase the art. So my question, I guess, would be, has that been discussed?
Well, banners typically are regulated by size rather than because you can have a sign, like a wall sign could be painted on. You have to, in that sense, it's usually defined by the words and the logo and the size. For a banner, it's typically just the overall banner size that's regulated. And so I'm not sure.
I'm speaking of your example in the lower left-hand corner of your slide. Those sorts of art.
Right. So,
as you mentioned, seasonal flags, pieces of art, etc. If they're paid by a sponsor, as has been a trend lately. So I was just wondering if that had been discussed, because it changes fundraising for certain imagery and art as it's been perceived in the past.
So just to make sure I'm answering your question, Commissioner McCrory, your point is that if the banners in the lower left-hand corner had a logo, if they were art, they were seasonal, but if they had a logo from, say, a bank or some sponsoring entity, would that change it? We have actually discussed that. We hadn't reached a conclusion. I think partly it's to understand if that moves it from being a commercial to a non-commercial sign. That was a concern. But if that isn't our issue, do you have direction or feedback for staff that you would provide?
Kathy, you're muted.
excuse me, sorry. Lucy, not at this point. I don't have feedback per se. I can get that for you. It's just, it was a question because, again, I know many nonprofits that have helped beautify different areas of our community with seasonal art, but the way they pay for it becomes a little red flag in my mind.
Sure. And I think that we are conscious that that is pretty common. And yet we don't want the art to become just a tiny portion of a much bigger logo. So I think we'll need to explore what that is. But I appreciate you bringing that up, and that'll be another piece for us to address.
Thank you.
I have another question from Commissioner Freeze. Is that how you pronounce it?
Priest, yeah, that's close enough. Not fussy about it. My question is about the art that isn't a sign. I get that, if it is a representation of something that's meaningful to the business, like a donut to a donut shop, or if it has a logo in it. I'm just curious. It's clear that it doesn't matter whether it's for sale or not. So if there's a piece of art that is for sale but doesn't represent a logo or represent a symbol that is representative of the business, it's not considered a sign.
Right. So let's say a car dealership wanted to have a donut. I think that could be considered art and not a sign. I will say that we have struggled. Brown Bear Car Wash is an example. They very typically put a sculpture of brown bears out in front of a car wash. I know that I was not a part of that discussion, so I don't remember exactly how it went, but I know that was a struggle to try and balance the artistic aspect with the sign aspect.
Thank you.
I have a question from Commissioner Brown.
My question is around holiday signs, for example, that's related to religious symbols. So, for example, or in Hanukkah or Christmas time, you have various specific religious symbols that could be perceived as decoration. Is that something that falls in this category as well?
Right. So if I'm Commissioner Brown, I am having a hard time hearing you. So if I didn't get your question completely correct, please let me know. Holiday decorations are not considered signs. Previously, the sign code listed them as not needing permits, and we're saying holiday decorations are just exempt from the sign code. I believe that when we get into potentially religious symbols, those would be non-commercial signs that would be potentially fall into separate regulations. But I may phone a friend here and ask Daniel Kenny, our legal attorney, that was redundant, our attorney, to help me out with that. Daniel?
Yes. Can everybody hear me okay?
Yes.
Great. Commissioners, Daniel Kenny with Ogden Murphy Wallace, your city attorney's office. And I've been before both groups on different occasions, so good to see you all, and happy to be here to support Lucy in this sign code project. And I think I would concur with what you said, Lucy. I do think, we're touching on two areas here that are probably, now that we think about it, probably some of the fuzzier areas that we've got, because what is art and holiday decorations is tough. For holiday decorations, we certainly would consider ideological signs as non-commercial signs. And so it would depend on the scenario and the sign that you're putting forward in your hypothetical. But holiday decorations also would be not considered a sign. So it just depends on what that expression truly is. And I think I would just take a moment to emphasize that for both art and these holiday decorations that we're talking about, there is a potential exemption from the sign code. But even if they don't fall within that, there still could be allowed under the sign code with a whole range of different options for that communication. So by having it included or not included in this particular section does not mean that it would be or not allowed or allowed. It's just what path does it have forward?
All right, thank you.
So I have a comment from Commissioner Fowl.
Thank you, Madam Chair. So to circle back to Kathy McCory's conversation, and I forgot what the commissioner was that discussed the art signs, like in the lower left-hand corner. If an art sign has the logo bearing an organization or establishment, as in like a co-advertising type campaign, but the intent is really to display the art, and then say maybe sponsored by XYZ organization. And the question, I guess, is to Lucy, if we have a absence in policy regulating that type of sign or art because we're not exactly clear where that line is, to Daniel Kenny's point about Christmas decorations, is there a problem with not having a policy in place? And if it becomes an abuse, then we can come back and create a or update to the sign code and just leave that questionable at this point.
Sure. Leaving things ambiguous is one way to go. And we can come back and update. You know, it's unlikely we're going to get everything spot on as much as we'll try. We would, I think, as commissioners bring up points, it's important to consider those and look at what other communities have done and attempt to shape the signs and these issues in ways that seem appropriate to the community. If your recommendation is that you think we should do it, that would be very helpful to know. However, there is the risk that someone puts up a large commercial sign with a small amount of art, and then it's an interpretation, and the city then has to either live with it or take some action. And so I think we hope to frame things in consistent with community expectations up front, with the goal of not spending our time at the hearing examiner or having to do code enforcement if we can.
Right. Okay. I don't want to get into the what if scenario because we could overanalyze this thing to pieces and not ever cover every scenario. And I just wonder how important that is for us because I haven't seen abuse of that. Not to say it can't happen, but I just haven't experienced it here in Issaquah or in other places. I haven't seen it either. So I kind of wonder if it's if it's just a no issue. Thank you.
Thank you.
I have a last comment from Commissioner Art. Till I understand how to say your name.
Art's good. One of the things that might make it easy is, you know, I don't want to see us prohibit the sponsorship of artworks. And there may be an easy way to say the sponsor is allowed to say sponsored by and their name, period. If it has a call to action, if it has a product image, if either of those are present, it is considered signage rather than artwork. So, you know, like if I'm a car dealer and I sponsored a wrap on some of the traffic light controllers, I could say, you know, sponsored by the car dealer, but I couldn't have a car image on it or my logo image. But I could have a picture of a donut if it was like National Donut Day. But, you know, if you said if it has a call to action, product logo or product imagery, then it is a sign. That may be a way to carve out a safe space for art sponsorship without opening up the door to, you know, fake art that is actually marketing sneaking in as artworks.
Thank you. I appreciate the suggestion.
There are no more questions.
Okay, on to the next topic. Permit requirements. This is a new section, but it does pull from some existing sections in Central Issaquah and 1811. Permanent signs, because that wasn't a big part of the Reed v. Gilbert, the requirements are generally unchanged. The process has been made consistent across the city and is primarily administrative, meaning staff will make them. We also addressed a situation that we infrequently, which is businesses wanting to submit a sign package. We welcome sign packages with multiple signs in it, but we've had some challenges knowing how they would be feed, and we tried to specify that to provide clarity for everyone going forward. Temporary sign process is entirely new. We're proposing that for temporary signs in the right-of-way or temporary commercial signs on private property, that someone would submit a temporary sign agreement. There could be up to 25 signs per agreement. There would be no fee for the agreement. The agreement would be valid for 60 days with 2 renewals. Therefore, you could have up to 180 days. And right now, you can only have 120 days. And then the last piece is the Front Street banner. There are, such as the image that's shown, there are currently 2 locations in the city that are used for these non-commercial banners. And mostly we're just specifying that it needs to be an equitable process, meaning that it is open to people, anyone who is interested in putting up a non-commercial banner. Any comments?
No, there aren't.
Sign zones. Sign zones is a new tool that we're proposing. We propose 4 sign zones in the city. The map below just shows you, based on the land use zoning, where the 4 zones would be located. There's single family, multifamily, mixed use, and non-residential. And for community facility zoned property or resource conservation zoned property, it's matched with one of the 4 sign zones which has the most similar intensity. So community facilities, which is where school buildings or fire stations would be located, would be able to do signs similar to non-residential. So we're trying to put like with like. Any questions?
I have a question from Commissioner Art.
It was on the previous slide, but just a quick question. Are A-boards or A-frame sandwich boards considered a permanent sign?
No, they are considered a temporary sign.
My question on that is, a lot of businesses, we use those year-round, so we won't be able to use them year-round anymore?
You will be able to use them year-round. You'll just have to renew your agreements on a regular basis.
So essentially, twice a year, you'll have to renew the agreements, get proof of insurance on.
The insurance piece I need to do a little more research on. I believe so, but every 60 days, you would either be renewing your agreement or submitting a new agreement after 2 renewals. The reason for this, instead of being able, well, actually, I believe I'm wrong, Commissioner Freeze. I believe that we actually have specified that A-frames can be up you get them for 1 year at a time.
Okay.
I
Yeah,
will,
that would be better.
Yeah, agreed.
And is there a cost associated with it?
No.
Okay, I just wanted to clear that up. I have a
There used to
question.
be a fee for that.
Right. In looking at past information, it turns out that A-frame signs are a relatively small amount of the income that the city receives. And by using a more consistent process for temporary signs, it's a relatively minor loss of income. Permanent signs are the primary, are 70% of the funds that we receive, even though it's a much smaller number.
I have a question from Commissioner Fall.
Thank you, Madam Chair. So this is Commissioner Fall. For Lucy, question is, when we're talking about A-frames, if an A-frame is if a commercial A-frame is located on a public space, and I'm going to use a specific example, Triple X has been displaying a A-frame sign on the public right-of-way at the intersection of Gilman and Front Street. It's been there for, I think, about a year now. How does that sign and this code, would that sign be out of code, I'm not exactly sure. Is that something that's allowable? If it is allowable, are we allowing businesses to put A-frame signs on public space?
Well, 2 things I would say. One is that while we've been in COVID, there's been a moratorium on certain sign rules have been lifted as a result of COVID to support businesses. But the other piece, and this is part of the reason why we want to bring our sign code into compliance with Reed v. Gilbert, is we haven't been able to enforce certain aspects of our code. Because the code is not compliant with the U.S. Supreme Court case. So as we're coming out of COVID, I think the city regulations, the moratorium on enforcing certain sign pieces relative to COVID continues through June, and the city, I'm sure, will revisit it as we get closer to that date to decide how we're doing and whether that is something to continue or not. And then with the adoption of this sign code, we will again have a tool that we can enforce.
Thank you.
No more questions.
Okay. So exception from permit requirements. What this section is addressing is there are certain kinds of signs that we say they're relatively small. The regulations are straightforward, and we don't require someone to get a permit as long as they remain in compliance with the sign requirements. The ones that are listed and the requirements generally match Central Issaquah and IMC 1811. We have added the sign zones in which each of those different kinds of exceptions are allowed. And we have added one kind of new sign, which is a drive-through selection sign. That's what we're at least beginning to propose calling it. which is the kind of, as you're going through a drive-through, there's usually a menu or some kind of selection board that is necessary. We are proposing that if you can see those from the right-of-way, they would need to comply with the regulations in this section and would not need a permit. If they aren't visible from the right-of-way, they would be just exempt. The reason we're doing this is there's been some confusion when drive-through businesses come in. If their menu boards are visible from the right-of-way, we've treated it as another sign, and it's been hard to know how to handle it, and so we wanted to add clarity. Almost 15 items were deleted from the exceptions from permit requirements. Half of those moved to the exempt section, which we previously discussed. 3 of them moved to other sign types, and 3 others were deleted because they were generally not signs. One was bulletin boards, for instance. That's the frame, not the sign. And so we really wanted to focus on things that were actually signs. Questions?
No.
Commercial permanent signs. So before, permanent signs were neither commercial nor non-commercial, but now we have divided our code between commercial and non-commercial. Generally, this section matches Central Issaquah for 2 reasons. The first is that Central Issaquah is built around a primary, secondary, and additional sign format, meaning each sign is identified as to whether it is a primary, secondary, or additional sign. We have found that's really helpful in terms of complying with the rules to identify which signs fall into which categories. The other piece was Central Issaquah is based, the city regulates the size of letters that can be on signs. Central Issaquah does this by relating the letter size to the size of the building or the size of the facade. IMC 1811 does it not by that, but by how far the building is from the right-of-way. And part of the reason that we don't want to do that is it created a kind of reverse incentive to put your building further and further away from the street, get a bigger sign. And it also meant that the sign wasn't in proportion to the facade or the building. And the reason I have a picture of Swedish in the upper right-hand corner is Swedish was built at the time that we were switching between these 2 approaches. And so the larger sign that you see on the front of the building and the smaller sign that you see on the side of the building were originally reversed. And because that was what was allowed, that little tiny sign had to be on the front of the building because it was right next to the right-of-way, and the larger sign was on the side. Once those rules were changed so that it was based on the facade, they actually traded their existing signs so that they could have ones that were more in proportion. In addition, we've added sign zones again, and a new type of sign called follow-through signs. These are the signs that you see in the lower left-hand corner. The upper sign is the kind of sign that WashDOT would put along I-90, for instance. And then to get that kind of sign, WashDOT requires that there are what they call follow-through signs, which means that their sign on the highway shows you turn right or you turn left. If you can't immediately continue driving right to that business, then they're going to want additional signs that tell you where additional turns are necessary. And without those, they will not allow you to have a sign on the highway. And it's something that we've struggled with in the city, and so we've actually added that, and the sign would be approximately like the Red Robin sign that you see on the bottom. To simplify the code, we've done a couple of things. One, where we have variations on a sign, we've bundled those together instead of treating them as separate signs. So painted wall sign, painted wall mural, multi-business wall signs, and wall signs are all together with those different provisions under wall signs. We've also taken situations such as awning signs and canopy signs that have similar or identical provisions and put those together. We've deleted some signs and some provisions. One of the provisions that we deleted was a requirement that in a multi-tenant building, the requirement that signs had to be located where the business space was. We got a lot of pushback from various multi-tenant buildings about that requirement. We didn't get anyone thinking that was a good idea, so we're proposing to delete it. And as a result of the kinds of changes I described before, 14 sign types have been reduced to maybe more been removed, and we have about 10 signs now, but we haven't reduced any options. The only sign type that we are proposing to delete is the franchise sign. We proposed that with the Issaquah Highlands sign code more than 20 years ago, and I don't believe anyone has ever used it. And so we think that we should just eliminate that. Any questions?
No?
Okay. As a continuation of talking about permanent signs, permanent commercial signs, I want to also speak about monument signs for a moment. There are probably 6 different types of monument signs that are proposed in the sign code, in the existing sign codes. We have combined all of those under monument signs while retaining all the various options. For businesses, there were different rules between Central Issaquah and IMC 1811, and we have brought those together and tried to simplify them. So there are certain areas which are shown in purple on the map to the lower right, lower left. Those are where monument signs are allowed outright. That's the way it is right now. In the red areas, which are Central Issaquah, CBD, and Issaquah Highlands and Tallis, what we've done is eliminate the requirement to have to get an adjustment of standards to keep using your existing monument sign. What we've proposed instead is that if you have a monument sign at the point at which this code is adopted, you can continue until you redevelop your property. At the time you redevelop your property, you would have to eliminate your monument sign unless through the land use permit process, you're able to demonstrate that that is a necessary sign because your business or building would not be visible without it. Any questions?
No?
Okay. Temporary commercial signs. So this is a new category because, as I mentioned, we used to just have temporary signs. We have carried forward some of the provisions from existing codes, such as the types and the regulations. To speak A-frames, we have 2 different approaches, partly in recognition of the fact that some buildings are set much further back from the right-of-way. For an on-premises sign, which is the first choice, it has to be in front of a business and no further than 20 feet from the pedestrian entry. That works in a lot of areas of the city where buildings are quite close to or at the right-of-way. But there are also areas in which buildings are set back, and so if a A-frame, wouldn't be visible from the right-of-way, then you are allowed to have it up to 50 feet away from the entrance, but it needs to be the shortest distance between the sign and the visible primary entry so that it's not ending up very separated from the business. We will entertain alternate locations that have to be approved in writing if neither of those circumstances would result in a visible sign. And the types of temporary signs that have been removed or deleted have been moved to other categories. Questions?
No questions.
One provision that applies to both temporary commercial and non-commercial signs in the right-of-way is that we are requiring adjacent property owner permission. This is a result of various situations that have come up in Washington, and so it would be part of the sign agreement that you have received permission from the adjacent property owner. For non-commercial temporary signs, this is really, as I mentioned here, it's a new category. It just was temporary signs. This is most specifically in response to Reed v. Gilbert. Again, we're carrying forward many of the provisions. I think I won't say a lot about this because it's a big topic in the discussions later on. I just want to point out that often when we think of non-commercial signs, we think of political signs such as the lower right center and right signs. But in fact, there are lots of other non-commercial signs, such as a banner in at someone's house, for graduation or a birthday, or just banners on street poles. So there are many reasons that we end with non-commercial signs, not just political ones. Any questions?
No, there aren't. Yes, there is. I have a question from Commissioner Matt.
Thanks, Chair Probel. I got that one right in under the wire. It's probably a question for the attorney, which is the distinction between commercial and non-commercial makes a lot of sense to me. But, you know, I think a strict reading of Justice Thomas's, I believe, majority opinion might not allow this versus when I read Justice Alito's concurrence, he says that it's okay to distinguish between signs on commercial property versus signs on residential property. I'm just wondering, you know, have we kind of pressure tested that concept in light of kind of the sweeping nature of Justice Thomas's majority opinion?
I'm so glad that you suggested that the attorney respond.
I'm one myself, so.
I can tell.
Great question. Great question. So the Reed versus Town of Gilbert case did not deal with commercial signs, and there have been cases that have specifically not utilized the decision in Reed when analyzing regulation of commercial signs. There are some that have, though, and so it is a good question. In the Ninth Circuit, which is where we are, it has not been used. And so there is, since just two lawyers talking here, there's a split in the circuits, and there's a chance that there would be another Supreme Court ruling that would clarify that split. But for our purposes in the Ninth Circuit right now, and really what I would view as the unanimous, well, not unanimous, the majority of circuits are saying that it does not deal with commercial, and commercial speech just has a lesser regulation. The standard for the scrutiny is a lesser standard for commercial.
Got it. Thank you. I'm a little hesitant to rely on the wisdom of the Ninth Circuit as the Supreme Court routinely disagrees with them, but we got to deal with the precedent we're dealing with, I guess. So thank you.
I have a question from Commissioner Lewis.
Thank you, Chair Probola. Commissioner Joy Lewis here. I'm curious, Lucy, with this change of designation, how we're planning on dealing with checking requirements with having adjacent properties permission, or there's another place in the document where we talk about political signs when posting on people's lawns needing to have their permission. What is the plan for having these changes? Because I would assume that there isn't actually staff to be sorting through and double checking everything that's being vouched for on these applications?
That's correct. It would be in response to complaints. The idea behind the agreement is in some ways a self-certification process. And then if there was a concern raised or an appearance that an area was not compliant in terms of the size or the number of signs, then we would turn to the agreement as a way of understanding how someone proposed that they were compliant, self-certifying.
Thank you.
What prompted getting owner permission from adjacent properties?
And I yet again turn to my fine attorney friend, Mr. Daniel Kenny.
Yeah. Well, that's a good question. It's a tool that a lot of jurisdictions use, certainly not all of them. And it is something that's been around for a while. I don't want to overly dive into the legal analysis, but there is an underlying property ownership interest in the right of way in most circumstances, assuming the city doesn't own it outright in fee. And so that underlying property ownership interest belonging to that adjacent property would tend to say that if the right of way is not being used for transportation and utility purposes, the primary purpose of a right of way, that adjacent property owner has more rights to that property. In theory, they could get a right of way use permit and even possibly put up a fence, maybe even encroach a little bit with a garage if it's not interfering with the purpose of the right of way. And so the same concept is true. If somebody's going to place a sign that's not for those utility purposes and transportation purposes, that adjacent property owner should have more of a say in that.
I have a question from Commissioner Milligan.
Hi, thank you, Chair Probola. Nina Milligan here. Is this the place where you wanted us to chime in about the spacing of signs in the right-of-way and how we might limit the distance between signs? I can't remember where this comes in, but I did want to talk about it.
We absolutely want to talk about it. I think we will wait till the end when we're talking about the 5 discussion topics, if you don't mind. I have a slide that I think will have more information that will support that conversation.
Looking at the clock, it is now 7:40 and we are only halfway through these slides. So I'm not sure if you want to continue think about how long you want to continue. We might be here for a while to finish this discussion. There is another question from, I'm not sure. Is there a question from Matt? Oh, Commissioner. Okay, there's a question from Art.
My question had been answered just before, so I'm good.
Okay. So that's it.
Okay, I think we're actually over the hump, and the rest of the overview goes relatively quickly. General sign standards and administration, again, collected from various Central Issaquah and 1811 sections. The purpose was to add clarifying language where we had seen previous issues. I assume there are no comments.
There are no comments.
Prohibited signs, again, mostly matches Central Issaquah in 1811. Some elements were moved into this section, or we specified things that we have extrapolated from what was in the prohibited section for clarity, such as cabinet signs, feather signs, highway advertising, and crane signs. The right-of-way section of the code was deleted because we've moved it into all the different, temporary commercial, temporary non-commercial sections. But there is an one element of prohibited that tries to clarify what is allowed in the right of way. Any questions?
I have a follow-up on some comments that I received from the public from the Highlands. And I'm looking at the picture on the lower right-hand side where it's advertising on the whatever that's called.
Crane.
Would that be the same as advertising on the thing that goes across the road up in the Highlands?
Oh,
where
the
there's-
pedestrian bridge.
Right.
I think that the pedestrian bridge, well, what's on the pedestrian bridge at Issaquah Highlands is not a commercial sign. It's not about a business. It would be a non-commercial sign and then would need to comply with the non-commercial rules in the right-of-way.
So the Highlands could put up advertising a new streetery or whatever they had. They had the right to do that with a permit.
Well, I'm not sure a streetery would be considered non-commercial. So I think because it's supporting healthcare workers, if I remember
Okay.
the banner correctly, that is non-commercial. So it would follow the non-commercial in the right-of-way rules. The sign on the crane, typically it is the construction company. It is advertising the construction company. And so we've had some issues with that in the past because we have a rule that there are no signs over 65 feet up in the air or 65 feet high. Those cranes are much higher than that. And so we thought instead of having to explain this every time, we would be overt. But obviously, this is a proposal.
Okay.
Any other questions on this page?
No.
Okay. Non-conforming signs, again, mostly matches Central Issaquah and IMC 1811. There were some clarifying edits, and we will discuss landmark signs as one of the discussion topics. Removal of signs, again, generally matches Central Issaquah in 1811 with some clarifying edits. And then we've added some elements to implement the temporary signs and temporary sign agreements. Adjustment of standards. This is the last chapter. It mostly matches Central Issaquah's section for purpose and criteria. The process is changed. In Central Issaquah and IMC 1811, this is an administrative process performed by staff. However, because currently in 1811, the Development Commission looks at signs on major streets, and we've proposed to remove that responsibility because there's not a lot of discretion in those reviews. We have proposed instead that the Development Commission review adjustment of standards. There will be the same provision that 1811 has now of an informal review where the Development Commission can determine that they don't think it is necessary for them to review it and send it back to staff to make the decision. When the packet came out for this meeting, I sent the Development Commission the packet along with a more a longer explanation of the changes that we were proposing and the reasons behind them. I've heard from 3 commissioners, 2 regular and 1 alternate, and all of them said that they had no concerns with the changing of their role. They did make some other comments, and I will fold those into the tracking and preparation of the public hearing document. Any comments?
I have a comment from Commissioner Lewis.
Thank you, Chair Probola. Commissioner Joy Lewis here. I just wanted to say that I read this change as being very positive. We asked our development commissioners to do some heavy lifts throughout the year, and I thought that the way staff designed this, the way you designed this, Lucy, was really positive, and I'm happy to hear that they saw it that way as well. So I just wanted to say that this particular point I noticed and I appreciated.
Well, thank you, Commissioner Lewis. I appreciate that. That is the end of the overview, and it is an opportunity for public comment.
So with that, I will open it up to public comment and ask Kristen or whoever, is there anybody signed up for public comment?
Yes, we did have Randy Banneker sign up to speak. I have two phone numbers on here. One ends in 91 and one ends in 95. So, Mr. Banneker, if you could just hit *3 and let me know which one you are, I will unmute you if you're here. Okay, I have unmuted you.
Thank you. This is Randy Banneker, and am I audible?
Yes.
We're audible.
Oh, okay. Thank you very much, members of the Planning Policy Commission and Economic Vitality Commission. I'm Randy Banneker. I'm speaking tonight on behalf of the Seattle-King County Realtors. I'm going to keep my comments extremely brief and submit comments in writing just in respect for your time. But I wanted to note that we support the amendment package before you tonight and wish to compliment staff on the drafting of the package. We see that it meets the objectives stated for the code update. It's understandable, practical, and it aligns very nicely with the Reed versus Gilbert decision. Our members place a very high value on the opportunity to do business in the city of Issaquah, to work with your homeowners and folks moving into the city. Signage plays a tremendous role in that. We appreciate the allowance to post on-premises temporary real estate signage that advertises homes for sale, rent, or lease, and off-premise open house signage that's posted during open house hours. There's a question about how to avoid a situation where it's an open house 24/7, and I would just suggest adding the requirement that an open house, during an open house, the owner or the owner/seller or the broker must be physically present so that the house is available for inspection by a potential buyer. That language is included in just a few cities I can tell you off the top of my head: Renton, Sammamish, and unincorporated King County. The last thing, just two other points I want to make is that signage, real estate signage, is extremely important in the process of buying and selling a house. About 50% of buyers find their way to that house with signage. And perhaps the most important message is that signs play a very important role in fair housing and anti-discrimination. Signs simply cannot discriminate. A real estate sign invites any purpose, regardless of who they are or where they're from, to know what's for sale in the community. It makes it impossible for any real estate broker, landlord, or owner or organization to deny that the property is available, and hence it makes discrimination substantially impossible. I'm going to leave it there. I thank you very much for your time tonight.
Thank you, Randy. Has anybody else signed up to speak?
No one else has signed up to speak, but if the person with the last two numbers of the phone number 95 would like to speak, would you please hit *3 and indicate so? That person has not indicated they would like to speak, so I think we can move on. There's no one else signed up.
So, Lucy, you're finished with your initial presentation?
The next thing that we're going to do is have a discussion about move on to the discussion topics.
Okay. The city has asked us to actually give them our input on some of these things. I will say that we have received several comments, written comments from the public, and I think some of them have been addressed already. If there are ones that have not been addressed, I would hope the staff would look at them and pay attention to them. They're too lengthy to go into all of them right now, but we appreciate the community for taking the time to add some more information to the sign code. So with that, Lucy, do you just want to go in and do the questions? I see another slide up on their screen, so I'm not sure.
So I'm trying to just display one sign, one slide. So I made a switch at a recommendation. I apologize if it's not appearing correctly. It's hard for me to know which view you're actually seeing. The first topic that we're discussing is the temporary non-commercial signs. And our goal is to try and find balance between protecting free speech and protecting and preserving the community character. These are new regulations. It is the most challenging part of the code and would impact both private property and signs in the right-of-way. Just as a note, our existing codes, temporary signs in general can be 32 square feet. Political signs are exceptions from the sign permit requirements for a 4 square foot sign, and then with a permit allows 32 square feet per face. The charts that we've had are replicated on the slide. I actually added sign height. I thought that might be something that the commissioners might want to address. The options of not regulating, requiring a minimum separation, or using the length of the property are provided here. I do want to note that the reason that I, again, as I said earlier, included the images here is that we often think of this as being political signs, when in fact it can often just be as simple as a banner on someone's property.
So there is a comment from Commissioner Art, but your questions do not go along with the ones that I see on screen. So I'm a little confused. So will Commissioner Art like to make his comment?
Are you not seeing the topic number 1? Are you seeing a different one?
I am seeing topic number 1.
I see topic number 1, but on the memo that we got, the question, it says the same thing, but it's a different question. It says, what technique is appropriate to support the speech while promoting safe sightlines and retaining our community character? And it gives us several options to discuss.
Right. Thank you for clarifying.
So,
Should I go ahead?
yes, please.
Okay. For temporary political signs, I would, personally, I think it's probably better to just go to up to 32 square feet. I think my understanding is Washington Code supports up to 32 square feet. I don't know that I'd want to make people have to get a permit to put a political sign that is supported by the state, the size that's supported by the state.
So the temporary sign agreement would apply here. So there wouldn't be a permit required. You would be essentially self-certifying that you're complying with the regulations. And just to clarify, are you, Commissioner Freeze, suggesting that we essentially option number one, that we not regulate spacing, we just identify a size and leave it at that?
I'm reacting to the existing code, 32 square feet with a permit. For political signs, I would prefer that we, and this is political only, I would say not regulate as long as they're under 32 square feet, as I believe is noted in the Washington State Code. I don't want to put any barriers or, kind of like make it easier or more difficult for different people in different situations to have equal access to having a temporary political sign. Other signs like birthdays and stuff like that, I'm okay with a different standard for them, but political has a particular, there's a particular entitlement to that through the state.
So,
Well, I just want to clarify that we cannot make that distinction. And I apologize if the way I structured the slide has led to this confusion. In our current code, because we haven't tried to comply yet with Reed v. Gilbert, we were able to make the distinction between temporary signs and political signs. But going forward, to have a code that complies with Reed v. Gilbert, we will have to have one standard that meets all those different kinds of signs. We won't be able to say, here's the set of rules for political signs, and here's the set of rules for birthday banners. We'll only be able to have one.
Okay.
That are set forth on, it was hard for me to understand until I went through the thing that all signs have to be treated exactly the same way, and that's the way the court has come down. You can't have a 20-foot sign for real estate and a 14-foot sign for political signs. They all have to fall into the same bucket. Okay.
And honestly, I think everyone struggled with this. It upended the way sign codes have been handled, I think, across the country, certainly in our region. And so it is something we've all struggled with, which is why it was so important to have a discussion with the community, because this is a new way of handling it. And we want to make sure that the provisions that we put out both, as I've said, protect free speech and maintain the character of the community. I believe I'm seeing little comment.
Yeah, this is a comment from Commissioner Fall.
Thank you, Madam Chair. And this is Commissioner Fall. So I have a question for Lucy. Actually, a couple questions. They're pretty short. Go to my OneNote here. As I read through the sign code, I did see things that referred to yard sale signs. And in terms of being able to, I guess, enforce the yard sale sign, do we want to require dates on yard sale signs so that if someone leaves a yard sale sign up for a week, someone who has the authority or a fellow citizen would be able to see that and realize that it can come down because it is now past a specific date. And the same thing also for like a lost pet. When I walk my dogs through on the Rainier Trail, sometimes I see lost pets. And I want to give the owners the opportunity to be able to advertise that their pet is lost, and respect that, and realize that sometimes putting a sign up on a public pole or something like that in a space where the pet may have disappeared is makes good common sense, and I don't have any problems with that. But do we have any regulation around that type of thing and how long that sign can stay up? And then my third question is referring more to a political overtone, but we have, in the last year, we've really seen this kind of come out, but we have Black Lives Matter flags and banners. So is it a flag or is it a banner? The rainbow flag, Stop the Steal, they're on vehicles, they're on stationary on property, whether it's a residence or commercial. Is there regulation along that? Is there guidelines that tell people that they can put that type of sign out? And typically, they are 4x8, so they are 32 square feet in approximation. So those are my three questions.
So let us talk about the dates on some of those signs. I think that it's probably beyond the capacity of our code enforcement officer to be pursuing that. And I believe that they're supposed to be located on private property, which means that we would probably not be picking them up. But I will add it to our list to discuss. In terms of lost pets, the one thing I would say there is you're not actually allowed to put signs on public poles. Doesn't mean people don't do it, but I'm not sure that the dates are going to solve the problem there, even though it would help people know how likely it was if that was still an issue. With the kinds of Stop the Steal, Rainbow, Black Lives Matter materials, those would all fall under the non-commercial signs. That is, I think, an essential part of what we're discussing with the temporary non-commercial signs that, for instance, at a house or an apartment building or a commercial building, what size banner or window sign should be allowed. And, right now, the community that we found that had a sign code that we've kind of borrowed heavily from for this section is Olympia. And in theirs, they did not limit the number of signs, but on single family property, for instance, they just limited each sign to 10 square feet. That could result in a lot of signs. Some communities have provided very specific limitations for the number of signs, no matter what kind of use. And I think, again, that is what we're looking to the commissioners to give us a sense of what seems like a good balance between visual impact and free speech.
Okay, thank you.
So there are three things on that slide that the city would like clarification on. So kind of think about it, and I'm going to go to a question from Commissioner Lewis.
Thank you, Chair Provola. Commissioner Joy Lewis here. I think that this first agenda topic is a good way to actually talk about something that you had said in the packet, which is to talk about speech inversely proportional to density. I think it's an important topic that we could spend quite a bit of time on, and I'd like to hear from everybody on it. I think it's something also that should really go as the equity board is formed and goes to them. Well, I don't want to stop our process here. I think it's an interesting topic to have them take up. I think when we talk about regulating the amount of speech effectively, we are talking about inequity. And so I'd like to hear comments that are kind of directed to that. I thought that was an interesting point in your packet. And I'd also love to have staff kind of talk to us about what are the common issues or pushback that we've had from the community in the past. I mean, are we again trying to solve a problem that maybe isn't a problem? Have we found that it's been a common thing of people putting a distracting amount of speech on their property? I think that's an interesting question, right, for this particular topic.
I'm looking at my chat to see if our code enforcement officer provides me with any information. At this point, he hasn't. And so from my perspective, which is much less frontline, I think that we all are aware that during certain political seasons, there's quite a bit of signage that shows up. But I think that we are trying to, again, it's similar to Commissioner Fall's comment earlier, that while we don't want to wear ourselves out with what ifs, I think we do want to try and give things some edges that seem a reasonable balance up front.
If you're looking for a direct comment on this, to be able to speed it along, I'd love to tell you that I think it's reasonable for the city to require a minimum separation if there is the concern of having a visual distraction. But I do think that exceptions should be made. For instance, if someone is putting a particular amount of flags to represent members of their family that are serving across seas, and that exceeds that number for the square footage they have, I think that there should be a comment section that says, I would like to exceed whatever that minimum separation is, and this is why, and it can be dealt with. So if there is going to be a regulation, I think there should be an availability of people when requesting their permit to say why and to have exceptions.
Thank you. Chairperson Probola, I noticed that Andrea Snyder.
Yeah, I was going to call on her next.
Thank you.
She actually said never mind later on in the chat down here.
So this is Andrea Snyder. Hi, everybody. I'm Andrea Snyder, the Deputy City Administrator. And I was going to weigh in on this question, but then I saw that our Code Enforcement Officer, Chris Grabowski, seems to want to make a comment. So I will cede to him and see if he has any additional information to provide. Thank you very much.
Thanks, Chair Provola. Commissioner Lewis, in direct response to your question, I don't have any personal enforcement experience in this jurisdiction with a proliferation of political signs on a single family residential property. So it's not a problem that I've experienced in this jurisdiction. In my previous jurisdiction, which was the city of Olympia, I did have direct anecdotal evidence of or experience with that, but that's under an old sign code under life pre-Reed v. Gilbert, so it would be comparing apples to oranges at this point.
Thank you, Officer Grabowski. It's nice to see you again.
Thank you. Good to see you.
So I have a question from Commissioner McCrory.
Thank you, Commissioner Probola. This is Commissioner McCrory from EDC. I have a question and then a comment. Just for clarification, when we say private property, we are referring to only residential property. Is that correct?
No, it would be all property.
Okay. That being the case, I think I think it's a broader conversation, because I think we're thinking of all private property being residential property. But my comment is, I do think that this needs to be regulated somehow, some way. And Lucy, I wish I could help you in achieving that. But when I think about temporary non-commercial signage, and I weigh that with our values of how we perceive our community, of the public safety that might become at risk with excessive signage, and then just ensuring that our businesses aren't buried behind other non-commercial signage when they're struggling, especially right now, to make sure their signage is out and being seen, only to be buried by other temporary signs that might arise by just doing away with regulating and to that point also enforcing. So again, I have no idea how to get there, but I am concerned with an abundance of signs that could actually impede our safety, negatively impact our businesses, and take away from the beauty of Issaquah, to be honest with you. Thank you.
Thank you.
I have a question from a comment from Commissioner Voice.
Thank you, Chair Probola, and thank you, Manager Sloman. I feel like the five-man band there keeps saying signs, signs. Well, I don't ever want to hear that word again. So I'm going to try and take a stab at what I think it is you guys are looking for. I'm going to say that option number 3 is the one that I seem to agree with the most. I think option number 1 is probably the worst. So to have absolutely no regulation by the city, I think would kind of go against Issaquah values, to Ms. McCory's point. And also, I think 3, even though there is going to be a bit of math for people to figure this out, obviously our corporations do that when they're coming up with their signage, when you guys showed that one particular corporate office off of I-90. It's not impossible. It may take a little longer for others, but if people are going to be producing multiple amounts of signs, I think that's not a lot to ask. I think the 5-foot rule, I'm open to hear about it, but it seems like things get cluttered pretty quickly. And I'm happy to hear Officer Grabowski's comment that he hasn't seen it in Issaquah. I guess my point is I don't want to see it in Issaquah. So I like the idea of it being basically regulated. I like the idea of the city of Issaquah still having a little bit of purview and still having a little bit of, I guess, the ability to have people comply with some of the regulations. So if you were going to ask me my opinion at the moment, I would go with number 3.
So how would you do that? You calculated on the length of the property, but you're still back to how many signs per foot, whether it's 5 feet or whatever. So what percentage of space would you like to put in there?
Are you addressing me?
Yes, I am.
Well, I don't have that magic number. I guess it probably would be a percentage. So the larger the building, the more amount of signs they could probably put, I would assume. It's pretty simple math. But I don't know if there's an actual standard, like a metric, like a percentage. I don't know if it's a foot rule. 5 foot seems pretty crammed. I mean, that's shorter than my height. So it seems like a lot could be lined up on a piece of property. I understand that, as far as the Reed v. Gilbert, we really can't make considerations for political seasons versus any other season. And I think I'll have a different question when we get to the flag portion, because I do also want to address Commissioner Lewis's point. If you have Memorial Day or 4th of July, when people put all those little flags in their yard. I mean, I guess there's a spirit to it. People, I know there's not, I guess I would hope there's more common sense, but I like the idea of the city still being able to step in and kind of regulate some of our aesthetics. And like I said, I personally like number 3. Number 1 scares me. Number 2, I don't know. I don't know if that's the best one. I don't know what metric that would be used that would be the most successful. But at the moment, from what I believe staff is looking for, I would say number 3.
So it's the direction, I haven't heard any comments against that, to go with number 3, but to have the city come up with the metric of what that's going to be. So if the metric comes up at 5 feet or 6 feet, you're going to have to make a decision on that.
Sure.
based on a picture, look at, what does it look like?
Well, I appreciate the challenge that we've given you, and part of it was the challenge that we faced. And Chairperson Probola is correct that we do often come with a polished draft. But we recognized that, first of all, we're doing something new and we're not fine tuning something. And this is a significant piece of reflecting the community. So even if we don't come away with an exact answer tonight, I think that the information that we're getting is very helpful to us in terms of going back and trying to come up with a final proposal that will come forward for the public hearing.
So I have a question from Commissioner Milligan.
Thank you, Chair Probola. This is Nina Milligan. The question, kind of two questions and they dovetail together, and I want to thank Commissioner Voice for pointing out the merits of number 3, and I would like to say that I agree with them. And backing up a little bit, the separation, the minimum separation of 5 feet doesn't seem to really, it's a standard, but does it speak to our concerns? Are our concerns having over signage? But then to me, my greater concern was safety and sightlines. Would that really achieve the objective? If the objective is don't get in the way of sightlines, then that would be an enforceable standard. But coming to it from even another direction is the permission. If we're talking about right of way and we're talking about permission of the adjacent property owner, and I'm sorry, there was so much to read, so Lucy, please remind me. When the property owner gives permission to someone to put signs in the adjacent right of way, do they have control over how many signs they can put in the adjacent right of way? Do they become the owner of the use of that adjacent right-of-way and how it is used? Or is that, and then the use is defined by this, or could the adjacent property owner say, hey, you can put one sign out there, and then the next person has to put another sign 5 feet from there? You know what I'm saying? I'm trying to put those two together when it's actually being applied.
We'll give it a shot and see if I've got it. If I've got your question, that is. I believe that the adjacent property owner, in giving permission, can probably use any criteria they choose. And from what Daniel Kenny has said to us, part of the concern is that since there is an underlying right to that property, because it is not in fact owned, it's sort of like an easement almost to the city right of way, most right of way. Having someone put a candidate that you are vehemently opposed to in front of your house or your business, you have the ability to say, yes to your candidate and no to your candidate. I think that, like many things, the city sets a minimum or they set a maximum, and then other things can happen as long as it's that you're compliant. And so what I would say is, they might grant one person the right to put a sign out and no more. And even though you would have a long enough frontage to have 5 signs. And that, as I understand it, and I hope Daniel chimes in if I'm getting this wrong, even though there is the ability to have more. And I think one of the things with number 3 that I would like to hear more about from the brave people who are willing to pick an option and put it out there is, one question related to that is, if a homeowner has a bigger piece of property, should they have more voice than a property owner with a smaller piece of property? That is kind of the implication, is that if you have a bigger piece of property, you get more signs. If you have a small townhouse property, you get less. Maybe that's good. Maybe it's that you have more frontage and therefore, there's more space for it. Or you might say, one house, one vote. And I'm interested in hearing more of the commissioners' thinking, just because it helps us when we go back to sort of sort through these various provisions that have been put out in as options to actually settle on one.
Well, for right now, we're going to have a comment from Commissioner Chris.
Thank you, Chair Provola. It's a little after the fact now, but I did want to comment on Commissioner McCory's concerns about public safety. One thing that the Supreme Court decision doesn't do, and Daniel Kelly can back me up on this, is it doesn't infringe on the city's right to stipulate time, place, and manner of these signs, regardless of what the signs say. So if a sign is in some way creating a public hazard, either it's encroaching into the traveled portion of the right-of-way, creating a pedestrian or vehicle hazard, or if it is obstructing the clear sight triangle, or if it is causing any other imminent danger in any way, the city is well within its rights to immediately impound that sign. So from a public safety standpoint, I think that we're still, we still have the ability as a jurisdiction to deal with signs that create that kind of a hazard.
So you have two comments. Is there an additional comment you want to make? You're in the chat box twice.
No, thank you, Chair.
I have a comment from you're going to have to help me with this one because I don't know first and last names. Anjali?
Yes.
Anjali.
Thank you. The option one, about the regulation, I think that's really important for the city of Issaquah to have some sort of regulation on the non-commercial signs in regards to the time frame period and how many signs that they can put it up. About the minimum separation, during the election time, driving on the Newport, Gilman, and on Tallis, it was a bunch of signs all clustered together. Was not a good sight because it was a lockdown and families were home. We were going for more walks, and it was not a great sight because it was just so much clustered. It looked like somebody has just made a big mess in the corner of the street. So I think a minimum separation, 3 feet, 2 feet, may be a good idea. And I agree with Lucy about the length of the property. It really doesn't sound very appealing to put that out, maybe because, as Lucy mentioned, that if you have a big house, it doesn't mean you can just put a big banner out there for something, and small house can just put very small little thing, whatever they're putting the signage up for. So I think putting that out there with the length of property, maybe not good for the whole community, sending up the message of like equal rights for everybody. So I think it's just length of the property doesn't sound really good for non-commercial signs.
I don't think you're going to win either way.
Yeah, I agree. Just a comment. So
thank you.
So I have a comment from Commissioner Zaragoza.
Thank you, Joan. This is Commissioner Richard Zaragoza. So I wanted to comment on, I certainly think that some regulation is necessary. The requirement for 5 feet separation essentially becomes the length of property calculated. If it's 100 feet within 5 feet, basically that becomes the same requirement. But I also felt kind of strong about the comment that Lucy Sloman made about the bigger the house, the bigger the voice. Then that felt pretty unfair to me. That a large house could have a dozen different signs, but a townhouse could have, with 5 feet, maybe 2. So I think capping it to the property, so everybody has the same amount of numbers of signs, no matter how large the property is, makes more sense to me as far as fairness. But it doesn't address, as you're saying, kind of easements where it's not owned by a particular person. But I guess it could still apply. As far as like what the number is, maybe what we can do is go by the smaller average. So smaller size houses like townhouses would have, I don't know, 25 feet. So what is aesthetic on a 25-foot property? Something like 3, and then apply that to larger properties. That's my comment.
Either that, you could specify no more than so many signs per property,
Yes, exactly. Yeah.
which doesn't cut into discrimination about size of property.
Yeah, I think it just would matter if it's a large number like 15, then on a small townhouse, it's going to look very cluttered, or it could be cluttered because you've given such a large number. Of course, on very large properties, 15 might seem like, too little, but I think it's better to err on the side of too little than too many.
I have a comment from Commissioner Freeze.
Couple of observations. One is that if you use 3, you're probably going to have some form of 2. Because let's say I have 100 feet, linear feet of length of property, and that allows me 10 signs. Under just 3, I could put all 10 signs at one corner of the property, 2 inches apart. So you're probably gonna, number 3, I'm entitled to X number of signs, but it doesn't say how far apart they have to be. So that doesn't say they have to be evenly spread across the property. The other challenge with things like townhouses and things like that is going to be what you do about the driveways. Like if you're in a 25-foot wide townhouse, probably 10 or 11 feet of that is going to be your driveway. So your practical limit becomes 10 feet. So you kind of need to consider that as well in crafting this. The last observation I'll make is for multifamily housing, when you think about things like condos where you don't have a dedicated, linear front, it's going to be very difficult to really maintain a strict numerical equity between a political signage for a condo and political signage for a single family with like 40 feet of front space. So there's some challenges there. Just need to keep in mind.
So we're going to take the last 2 comments and then go on to the next question. So I have a comment from Commissioner Fall.
Thank you, Madam Chair. So I originally had a comment to go back to Jason Voice's proposal, and boy, everybody had some really good feedback here. So I'm actually going to add on to it a little bit. I support Jason's idea of using number 3, and Art's suggestion of using number 2, which is also going to Anali. If we have if a property owner has 1,000 linear feet on the street, if we went with a fictitious number, say 0.2%, that would rounded to the nearest whole. That would allow them 3 signs for 1,000 feet. We could also say that that property owner could have three signs for that 1,000 feet, and a property owner that may only have 100 linear feet, we could say there's a minimum of 2 signs. So that property owner that only has 100 feet could have up to 2 signs or 3 signs based on that 100 by just putting in that there's a minimum that person can have, and based on the square footage. And then after that minimum, then it's based on linear feet. So that solves number 2 and number 3 in the same bucket. And then I think what we're also hearing is that people are talking about residential versus commercial. Should we treat residential differently than we should treat commercial? And then when we're talking about townhouses versus regular houses, typically townhouses, condominiums, and apartments that are then regulated by either the landlord limitations and or an HOA association. So if we're talking about limiting free speech of whether a person could put up a BLM sign in their window or a commercial sign in their window that meets the commercial format for residents, what happens when we're having that sign in a HOA situation? Does the HOA take priority, or is the city code going to allow them to override the HOA codes? And that's all. Thank you.
Thank you.
To have a last comment from Commissioner Carl.
Thank you. This is Janice Carl. I have just a couple of comments, and I'll do them very quickly. I really appreciate the suggestion that a couple of folks have made of a single maximum number of signs per property or lot, however that's going to be defined in terms of ownership. I concede the concerns about restrictions from an HOA or similar overriding set of rules, but I think that that's a nice way to manage the equity. So if we said 3 signs per lot, then that would be a reasonable across the board, regardless of the size of the lot. I feel that there's a fairly low need to ensure minimum separation between signs. The exception to this would be if you're worried about the ability to see around a corner or have visibility to traffic, but the displayer of the sign has an interest in making sure there is some separation between the signs, because if the signs are too close together, that inhibits the readability of those signs, and that's not their point. So I feel like that requirement is less critical. That's all I have. Thank you.
So Lucy, does that give you enough to think about?
It does. Thank you so much.
So
I appreciate everyone diving into the deep end of the pool with us while we try and sort this out. Thank you very much.
So we go on to the second question.
Yes. The second question, I put the hard one up first, so hopefully it gets easier from here. Second topic has to do with the Old Town Design Standards, which includes 3 pages on sign design. These regulations are different than the regulations in other parts of town, and even conflict with the regulations for signs in 1811. basically the existing code, each page has a topic. Those three are listed. Integration with architecture, building mounted signs, and whimsical artistic elements. Integration with architecture requires that you identify locations with the design of buildings so the signs fit with the architectural character and are proportional. I'm losing my ability to speak. Proportional to the building. The building mounted signs does not allow any freestanding signs with two exceptions. One is where you have an existing single family home that is being used for a business and you're allowed to have essentially a monument sign, or a multi-building, multi-tenant project. And again, you're allowed to have a monument sign. The third is called whimsical artistic elements. It is only guidelines and encourages highly graphic signs to convey products or services, use ornamental brackets, be pedestrian oriented, and allows a certain amount of additional signs. Cabinet signs and neon outlining of buildings are not allowed. So as the memo identifies, some of these are kind of challenging. A lot of the buildings in the CBD are historic, and so trying to identify where those sign areas go may be difficult, given that we don't have those at this point. And then tracking those over time, and then what is architectural fit to one person may not be architectural fit to another. However, if this is something that's important to the commissioners, it would be, we would want to update that. The building mounted signs, these are essentially monument signs, smaller than the signs allowed in the rest of the city. Again, is this an important feature of the central business district? And if so, then we would want to look at how best to do that to be consistent with the CBD. The whimsical artistic elements, some of these are either already prohibited, such as cabinet signs. Some of them are guidelines, or we already have additional sign provisions. So we're really looking forward to hearing from the commissioners to figure out, are there essential components of this that should be retained for CBD, or whether consistency is more important.
When you talk about CBD, are you talking about all of Old Town, or more specifically Front Street and Sunset where the businesses are?
That's a great question. Old Town is much bigger than CBD. CBD is the actual zoning area that this applies to, as I understand it. And so this is primarily Front Street and maybe the first half block of Sunset. So it really is Front Street just south of Sunset, north to, I think, about where the creek crosses it.
So the CBD, Front Street, is, I think, a complete different element of the city. I don't think that you can lump it in. There are too many differences, too many things that add art and color and things to make that part of the city different. And I don't think you can just go and say all of these other rules apply. But in order to get a sense of what is important, I think somebody has to dig deep into what is essential and what can be put in to have a hybrid. But I really think that there are some things that need to be different based on where it is.
Thank you.
I don't see any other comments or questions in the. I think you need to talk to Dia. I think you need to see what they have had down there and what they think is coming. So, I have a comment from Commissioner McCrory.
Thank you, Commissioner Provola. Commissioner McCrory here with EVC. I just want to say, I think some things could pertain temporary signage, for instance. And I do agree that some of the design standards that exist now need to take into account the architecture of the downtown core. I would hate to see that go away. I think the business owners down there have done a great job thus far of making sure the signage complements the buildings. So I do think, I agree with Joan that I think that the integration of architecture needs to remain specific for CBD. On the other hand, I do think there's some areas of commonality with the temporary signs, et cetera, that could flow throughout the city. Thank you.
I have a comment from Commissioner Lewis.
Thank you, Chair Provola. Commissioner Joy Lewis here. I agree with previous comments that have been stated about CBD being designated separate. And I believe in your memo, we actually talk about it adhering to the Old Town standards. And I believe that we do actually speak about that in the Old Town standards. And so standards. So it's something that I believe is actually addressed. So when we kind of think about it versus the rest of the city, I think it is important to think about the CBD as being a part of Old Town and being that gateway into the community. And so I'm more closely aligned with that view. I also think that as we've looked at whether it be our designation of how we see our city expanding in the future and Mall Street, for instance, the plans that we have next to the Raleigh property and development build out, we see us wanting to create really more identity with our neighborhoods. We've worked a lot on that in our commission. And I think that allowing that room is important as communities want to help define and create that sense of space. And so having the CBD be different from what the rest of our sign code is for the city, I think adheres to the kind of overall plans that we've talked about. Thank you.
So I'm assuming that Commissioner Castler just made a comment in the chat.
Hi there. Yes, I just wanted to say that I agree with the last three speakers. And I think the other thing to consider is because Old Town and some other areas that are connected has been designated as a creative arts district, I think we need to consider that as well, because it does tell us that art is going to be a core, and then whatever we decide, in terms of the signage, art versus logos and all those things, we just need to be very cognizant that there are some different things at play.
So I have a comment from Commissioner Boyce.
Thank you, Chair Provola, again, and I want to thank Commissioner Lewis for stating it so well. Yeah, I do believe CBD is an important and integral part of our city, and as someone who lives next to it and spends a lot of time near it, it is unique, and I believe that uniqueness has been thought out, well planned out by different commissions, and I think it should be retained. So to keep CBD consistent with the city, I don't believe it would be appropriate. It is a unique part and feature of our city. So retaining all of the sign design provisions that people have spent so long coming together and putting that together, I think would be appropriate. To Commissioner McCrory's point about temporary signage, we've seen this through the pandemic with basically like a moratorium so that businesses, like, I won't name businesses, but specific ones on front streets were able to use A-frames and to advertise as a way to help provide some relief. So number two, I guess, retain some, not all sign design provisions that seems enticing, but yeah, definitely want to keep CBD unique. So I would scratch number 1, leaning towards number 3, but I could understand how someone could make an argument for the near future and possibly permanently for maybe a few small revisions. So thank you.
I don't have any other comments in the chat.
Hey, thank you. Number 3 is the directional and informational signs for business and civic purposes, which is a provision from the Central Issaquah sign standards. The information includes maps, business names, civic sites. The one example that we have in the city is Issaquah Highlands, which has about 10 or so of these in right-of-way with one on public land, and they're managed by the Issaquah Highlands Community Association. And it's tricky to figure out a way to maintain these. It would probably require us to develop a master sign plan program. And so we really wanted to find out from the commissioners whether this was important to the community, and whether we should pursue trying to figure out what kind of program we would need to have to retain them, or whether we eliminate this kind of sign. That would not require that these go away, but it would make them legally non-conforming, which means that if a car ran into them or just as they wear out, they would not be able to be replaced.
I think they are a positive contribution to the looks of the Highlands, and I would be very disappointed if they were eliminated, even one by one. So I think that we have to find some way to continue them. I have a comment from Commissioner Mulligan.
Thank you, Chair Probola. Nina Milligan here. Lucy, I have a comment and a question. One is, thank you, Chair Probola. I agree with you. I live and spend a lot of time in Issaquah Highlands and really enjoy these, and I think they're a valuable tool. I would hate to see them go away. They are, as we've just been discussing about Old Town, a unique feature in Issaquah Highlands that's very nice, and it's a very compatible with the personality of the walkable community to have these kiosks, not just with directional signs to businesses, but also informational and inspirational posters in them. And then, so the question, Lucy, is are there other, these came about perhaps through something that was allowed in the development agreement, and then we become after the development agreement part of the regulations in the IMC. What other, in Rowley or in Lakeside or something like that, would they be allowed to build these signs, and then once they come into the city and the IMC, then they can't have them anymore? You know, is this, is there a way that we can look forward to the other development agreements as well?
So you're right about the history of these. It was ironically the follow-through signs that we are trying to allow, we proposed to allow in the city, that was the genesis of these kiosks, because some of the businesses up on Park Drive felt that it was difficult for people to find them, certainly before smartphones. And people trying to get to businesses, they could not put anything up on I-90 because there were too many turns, and they wanted to follow through signs. The master developer proposed the kiosks as a solution, and then it was brought into the development agreement. Then when some of the later development agreements came along, such as Rowley, Swedish, Lakeside, and then Central Issaquah, they continued that forward. The placement of them, and the point of them was to allow them in the right of way so that they were positioned to serve both pedestrians from the sidewalk and cars from the travel lane. it's the positioning of them in the right of way that is the challenge. And so I think there may be ways to address it. I think we just, before we spent a lot of effort trying to craft a program that would allow this, I think we wanted to get the commissioners' input before making that investment, that yes, this is a program to be carried forward. And it sounds like something that we will be exploring before we issue the draft.
I have a question from Commissioner Fowl.
Thank you, Madam Chair. And to Commissioner Probula and Mulligan.
Probula?
What did I say?
I don't know, but that's okay.
Okay. I think they're a great asset, and I would like to continue to see them in the future because not everybody has navigation on their car. Not everybody's probably going to want navigation on their future car, and they don't create a distraction. So I think they are an asset to the community. As far as I think when you had made a comment, if they're vandalized or if someone ran into it, who would replace it? The city wouldn't have any stake in this except for the fact that it is on public right of way. If that's correct, then I don't see any negative to having it. If the city's on the hook for replacing it and maintaining it, then I kind of question whether or not that's the right business model to have for this, but I do support them.
Thank you.
I have a comment from Commissioner Lewis.
Thank you, Commissioner Joy Lewis here. I think one of the issues with number 2 is the issue of the non-conforming, right? And the idea of having something right now that serves a purpose and is useful, becoming something that as it becomes dilapidated or needs care, just is slowly eroding in our community with the non-conforming. And so I'm against having that be an option for the particular signage. I do want to comment as a former commissioner for the UBDC. We had overwhelmingly positive comments in the Highlands for these, and they really did help increase that walkability in that sense of a carless community. And so as we look forward to a future that has a little less cars, I do think that it helps contribute to the overall direction that we want to go as a city, especially in particular areas. So I do want to voice that I think that there is a space for them. How much you need to invest in a program right now is debatable, but certainly allowing that option I think is a positive one. Thank you.
Thank you.
I have a comment from Commissioner Voice.
Thank you, Chair Probula. I'm in agreement with all of my fellow commissioners that have just spoken. I think they're an asset. I think, again, to Commissioner Lewis's point, as people become more multimodal, these will become assets. You can even put them in the CBD as long as it follows the character. So having the city develop a program that allows the business districts to have these similar kiosks, I think would be appropriate. My fear is similar to Commissioner Fowles, who is on the hook for these if they are most likely not necessarily to be damaged, but vandalized. And nobody wants to look at those eyesores. So I'd be interested to hear more about the maintenance and the upkeep of these kiosks, but generally completely in favor of one. So
Just to be clear, there is a kiosk in downtown, right next to Stan's Barbecue. So there is one already down there, which is being maintained by DIA and adds some nice contrast to it in the city. So, shall we go on to number 4?
Topic number 4 is flags. Jurisdictions are inconsistent about whether flags are regulated by sign codes. It's many different approaches, especially in dealing with governmental flags. Non-governmental flags, such as flags with business logos on them, could or would be handled like banners. Currently, the code accepts from sign permits flags up to 25 square feet. In central Issaquah, you can get a permit for a flag larger than 25 square feet, but there isn't a maximum. It's a little wishy-washy and I think would be hard to enforce. I will tell you, I don't remember anyone applying for one of those. The concern that brought this to our attention is that in other communities, monumental flags have been installed, for example, up to 3,200 square feet, which is the one that is pictured below. These large flags can be distracting and noisy. So we're interested in the commissioner's recommendations about whether we regulate this and what standards we apply.
So our first comment is from Commissioner Fall.
Thank you, Madam Chair. So I had a conversation with Evergreen Ford Chevrolet. When they moved to East Lake Sammamish Parkway, there may be a discussion of having such a flag at that location. And so this might be an important conversation. How big would we as a community think is an acceptable size flag if they decide to go for maximum? Thank you.
Thank you.
I think we should be more concerned with having a flag that size in any residential area because they do make a lot of noise. I have a comment from Commissioner Freeze. Whoop, take that back. I have a comment from Commissioner Milligan.
Milligan. No, thank you, Joan. Commissioner Milligan here. The size, the direction you're taking with the size is fine. I thought I saw in our packet a question about whether flags could only be governmental representations of a city, county, or state. And I just wanted to chime in about the POW flags would be something that is part of a flag flying etiquette, and it's not included in our code. So just want to make a note of that.
Now I have a comment from Commissioner Boyce.
Thank you, Madam Chair. I believe I'm right behind Commissioner Freeze.
Yeah,
I had to do that at least once this time. Okay.
Not a problem. I would prefer number 3. Dealing with it as an exception allows you to control, have a maximum, but between the maximum and the 25 square foot kind of limit, you would be able to take local conditions into account, like how, do a test on seeing how big it is before it gets too noisy. If the flag's out in the middle of nowhere, maybe not care as much that it's a little larger, a little noisier. But I'm not sure, I don't know that I would just say 25 feet and be done with it. I would have, like a standard size, a maximum size, and then between the two, it's an exception process.
Thank you.
Commissioner Boyce.
Thank you, Chair Probola. I have had the privilege of following some amazing comments by other commissioners, so they're making my work pretty easy tonight. Again, I would agree with number 3. Kind of believe in that rule, if it ain't broke, don't fix it. It seems to be the rule that's been governing the city of Issaquah for a while. And I do like what Commissioner Freeze just says. I like the city being able to offer special permits, but having that under their purview. I think, I can only speak for myself. I love to see Old Glory flying, but I don't want to see something like when you're driving on the way to Tacoma and you see that monster of a flag. I mean, that thing is got to be the size of a basketball court. So not really goes with the city. So again, having the city be able to offer special permits or make special exceptions, I'm okay with, but at least someone in the city is able to have a purview, have a little bit of control over what's acceptable. I think a 25 square foot flag is, I believe that's pretty big. That's 5 by 5 square feet. To be able to not have to require a permit to do that, I think is fine with me. I did have a question, however. So you had mentioned company flags. So I'm thinking of like Costco. I mean, I imagine they're going to fly the Costco flag from their headquarters. How would that work? Is that a banner or would that be considered a flag?
I think we're going to treat them as banners because it's, sometimes banners are stabilized at the top and the bottom, but we've seen banners that are flown like flags, flags that are flown like banners. I think that we want to make that distinction, consider flags governmental, cover business things as banners. Commissioner Milligan brings up a good point about some other kinds of non-commercial flags that we should consider how and if we address that. So more internal discussion it's clearly needed.
I can't remember where I saw it in the packet, Ms. Sloman, but somewhere I mentioned, and I don't know if it was in the flag section, but quasi-governmental. I would think the POW flag would probably fall under that. And then one other thing I would add is just something earlier to our conversation about temporary signs in residential areas. The city of Sammamish does a great job, and the city of Issaquah does too. During the 4th of July upcoming week, where people plant flags everywhere. It's beautiful. It's wonderful. Memorial Day. Would a flag in a yard be considered a flag or a temporary sign?
I think if it is a governmental flag, the little ones that they sometimes plant as a field, I think it would still be a flag. And I believe that the exception from sign permits as written currently does not specify a number. So I think as long as you're under that 25 square foot limit, there's not a numerical limit. And so I don't think that would be a problem, but I appreciate the reminder that that does happen.
Great, thank you.
So just as a clarification, the flags on Front Street, are they?
Are these the ones that that are from light standards?
That are attached to the buildings that Kiwanis puts up all the way down Front Street.
Thanks for that reminder too. I will. It's important to have all of these options on the table to make sure that we're getting the right regulations for the situations that we find.
Okay, well that, if we weren't able to put up those flags on the 4th of July, I think that the city would be very sad. So I have a question from Commissioner Lewis.
Thank you, Chair Provola. Commissioner Joy Lewis here. I'm curious, when we talk about flags, I think really we also need to be talking about poles, right? How we're hanging our flags. And so when we talk about the regulations on height of the ability to build a pole large enough to hang a monumental flag, I'm not aware that the code allows for that right now. So I'm not sure if that actually catches this without needing to designate it specifically in sign code, but you can double check that for me. I don't think there's any place that's appropriate in our community to have a monumental flag. However, I do think that if it's for a timed amount, then that could be an option as well, like Joan mentions, for specific holidays. I do want to piggyback off Nina's comments, that there are a variety of flags that are non-governmental. She brought up a great one. Another one that I hold dear is the Gadsden flag. It's been co-opted by the Tea Party and now the Stop the Steal movement. But prior, it was the flag of patriots. So there's a lot of different flags that we fly and that have a lot of different meanings besides even our strict governmental ideas. So I do think that there needs to be a reconsideration right now. The definition on page 28 is very strict. I don't know that that is that is where we want to go. And I would love for you to also remind me, so I don't have to look in my packet, what we say the size regulation is for banners.
For banners?
For banners, yeah, because we're basically treating everything that isn't a governmental flag a banner.
Well, there are a couple of different sizes. It depends on whether they're commercial or not, and then whether they are on light poles or not.
So I do think that gets trickier when we start thinking about designations of pride flag and such, as far as again, you know, we're supposed to be really looking at this as being content neutral. And so we have a really strict definition on flags, and then banners, it starts to get a little bit trickier. And then where does it end up falling when you're having patriotic sentiments that are typically often on a flagpole? So I do think that this is a situation that needs to be where the administration needs to decide. This is where we strongly feel, because I think there is right now a lot of wiggle room, and it would be nice to see you guys tell us this is what we want. We can tell you, I don't know if I feel like that, but right now I don't know that we can put up a pole for a monumental flag according to just height limits. So I would bring that up.
I would like you, go ahead.
Well, I was just, I appreciate you saying the last part, Commissioner Lewis, because, right, there's height limits. There's also the kind of permit you would need to construct a pole for a monumental flag. I mean, just the structural and such. I think that there is a certain, it might be 20 feet. I believe you can put up a 20-foot pole without needing a permit. But beyond that, it may, but then how that fits into the height limit, I will do a little more research on.
And then how that fits in with our lighting code, right? Because generally then when you put in a flag of that size, you want to uplight it, right? And so then you're talking about, Ron brought up the example of a relocation for the car dealership. I mean, that's right by a creek. So you're talking about noise and light now for the other citizens of our community, our furry and winged friends. I mean, there's a lot of considerations that have to go into not just, I really like giant flags, so.
Well, I think that my understanding, and I am not an expert on this, but the lighting of flags is an important consideration. I don't believe it has to be uplit. I think that is the most convenient form of lighting. If you aren't taking the flag down every evening, then you do have to light it to leave it up in all kinds of weather. But I believe that there are more directional lighting that is possible, but it is an important consideration when you think about the larger the flag, the greater the light that's going to be necessary, not have to take it down every evening.
Thank you very much.
Since we started this discussion with making sure that we complied with the Supreme Court's decision of being content neutral, I think that maybe you should run it by the attorney. Does it fit the same requirements as A boards, where every A board has to be the same size, but we can't dictate different sizes for different people?
Okay.
I have a comment from Commissioner Freeze.
Yeah, a couple of things. I'd like to echo we need to consider flags from a functional perspective, not a content perspective. We need to think about things like the POW MIA flag, the rainbow flag, the other important flags that people use. The other thing that hit my mind is we need to think about, if I have an 80-foot building, I can hang a 75-foot flag from the side of the building without a flagpole. What do we do in that case? And then the last comment is, I would want to have something in the code that allows construction workers to, and the crane operators to still put a flag up on the crane or the building. It's tradition when you top off the steel for a building to hoist a flag on the building. And I think it's a tradition I wouldn't want to make illegal.
I have a comment from Commissioner Brown.
Yes, thank you. Can you hear me okay?
Yes, sir.
Oh, good. Thank you, Chair Provolar. Provolar, did I pronounce that correctly?
Yes,
Sorry.
you did. Yes, you did.
I'm torn a little bit on this topic. As a veteran, obviously I favor the flag and the waving of it as much as we can. However, knowing that especially large flags on a pole can make horrendous sounds in the wind. I mean, decibel level is sometimes ear piercing. So keeping that in mind, I would not opt for number one, the option one. And certainly option two wouldn't be an option for me either. In regard to, you could put large flags on the side of a building and not make any noise. However, on a flagpole, like I said, it could make tremendous amount of noise. So what I would favor number three, having both an exception to the size and also keeping in mind what would that the maximum be for a flag to be on a pole to minimize somewhat the sound of it from the wind, flapping it from flapping it. That's it. Yep.
I have a comment from Commissioner John. There is no last name, so I don't know who that is.
Hello, I had a question, but it's now been addressed, so let's move on.
Okay, thank you. Is there anything else in regard to this? Lucy, do you have your?
I do, thank you.
Okay, I think we have one more topic.
We do. Landmark signs. Both Central Issaquah and IMC 1811 have landmark sign provisions. The current code dates establishes December 31st, 1965, or more than 55 years old as the cutoff date. I think that was probably established in the 1990s. I looked today, I have not found a record of any signs being designated as landmark to date. But we do have some signs that I certainly hear about, which are the three that are shown, mostly, partly as signs in their own right, but sometimes just as in association with beloved businesses. So we're interested in hearing from the commissioners about whether we should change the date or not. 40 years is a common date range for landmark signs, and whether we should, through the adoption of this code, establish some or all of these signs as landmark signs. These are XXX Root Beer, the Grange, and the two signs with foams.
I have a question from Commissioner Boyce.
More of a comment, but thank you, Chair Provola. So number two makes no sense to me, right? Because it literally says keep the date, but identify signs to landmark even if they aren't that old. So that one seems kind of absurd. So I think number two gets kicked to the can. Keep the date the same and not classify any signs as landmark signs. I think I like option number three. I don't know what it is tonight about option number three, but it seems to be the number for me. I think we can be, again, if that was actually adopted in the 1990s, okay, that was what, 25 years, 35 years. My math's a little off, it's late. But we need to be able to shift. That was 30 years ago. So what was a landmark in the 1990s? For some of us, the 1990s are a landmark. So that needs to be a moving target. It just needs to be a moving target. So for what it amounts to, I'm going to go with lucky number 3. Thank you.
I have a comment from Commissioner Lewis.
Thank you, Commissioner Joy Lewis here. I agree with Commissioner Boyce's comment. I think that it should be a moving target, right? So I think it's important to say if that was the date that was selected in the 90s, that we have continuity. I'm not in favor of landmark status for these particular signs. And if we do end up keeping the date, I think it's easier to they're not about to go anywhere. I don't think that we have a protection that ends up happening necessarily. So I do think I am in favor of moving that as a moving target as suggested. But instead of having a landmark status, I would direct it to our Issaquah treasures, and I would then instead say if it's been designated a treasure, then we should be able to then. So that kind of gives us a wider range of maybe signs that would have it rather than designating these 3. But if they're a treasure, then it kind of then has a default kind of exemption built in. Thank you.
The one thing I would add to that comment is probably the Bohms and the Grange sign can be replaced now that they are outside of central Issaquah. But the XXX sign is probably legally non-conforming, which means that if there was a fire or hit by lightning or some act, I'm not sure that it could be replaced as is. And so that is the consideration of making it a landmark that allows its rebuilding to match the existing sign in spite of being legally non-conforming.
Agreed. I think that I would give a broader categorization that would designate any signage that is associated with an Issaquah treasure of having that exemption rather than landmarking these specific 1, 2, 3 businesses, I would say.
Thank you for clarifying.
Comment from Commissioner McCrory.
Thank you, Commissioner Probola. Kathy McCrory, Commissioner with the EVC. I definitely agree. I think 3 is a better way to go. I also agree with Commissioner Lewis. I'm not sure that I know all of the landmark signs in town to exempt one just because we weren't aware of it. So I think having those jewels included just in case. Again, it's late and I'm trying to drive through town in my mind. I'm trying to envision Top Pot, to be real honest with you. Is that one landmark or is it on top of the building? Or is it, is it a monument sign? And again, I just am in agreement, number 3, and I love the idea of if it's a treasure as well, that should be considered.
Commissioner Fowle.
Thank you, Madam Chair. So I'm going to make this kind of quick. To Kathy, Commissioner Kathy and Commissioner Lewis's comments, I agree with them. I think they are naturally treasures. But understanding what Lucy was saying about landmark status, as long as they are protected, I think that's the goal. I think that's what people here want to see is that they're protected. So if XXX had a fire, they would be able to rebuild to the old standard. So they would be able to recreate it. And I think that's important. How we get there, I think is up to the city to decide, but I think it still needs to be protected. Thank you.
So I have the last comment from Commissioner Milligan.
Thank you, Chair Probola. Nina Milligan here. Thank you. I agree with, it seems like a consensus that to change the date, I'm seeing 40 years, but I am reminded in looking at other building landmark times that the city of Seattle, I think, has a 25-year kind of rolling standard for being considered as a landmark. And then, of course, then we're talking about being considered as a landmark or whether they are automatically landmarked. Those are two other things to talk about. And I would like to defer to the expertise that we have in our city, so wonderful. And Erica Menyes at the Historical Society, I think she should be reached out to on this topic.
Lucy?
Okay, I'm just writing as fast as I can. Thank you. If there's any public still here, this would be an opportunity for them to comment on the discussion topics.
So I'm assuming that what I was getting at is your presentation, and there's nothing else that you want to come up with. So with that, I will ask if there is anybody else who would like to speak on this topic, these 5 last questions, or even the first one, if they so choose. Kristen, is there anybody signed up to speak?
No, they have all left the meeting.
Yes, it is not normal to have a 3-hour meeting. The last time I think we did it when we were doing the central area plan, which took a while. So with that, I'm going to ask Kristen if there are any reports that she wants to update us on.
Could I just add one brief thing, is that these are the next steps that are coming. So we return for the public hearing on April 22nd, and assuming that the commission, PPC, makes a recommendation that night, then we would move on to the council phase with a study session and tentative adoption. And that concludes my presentation. Thank you.
Kristen?
Hi, this is Kristen. I do not have any reports to provide tonight. I don't know if Deputy City Administrator Andrea Snyder has any reports.
Is she still here?
Hi, everybody. This is Andrea. Yes, I'm still here. And no, I do not have any other reports other than I think we wanted to make sure that we introduced Minnie Dollywall, our Community Planning and Development Director. She started on Monday. Today's day 4, and it's amazing how much she's already absorbed and the great questions she's asking. We're so excited to have her as part of this team, and I know that each of you are going to be working with her in a different capacity, especially our PPC members. Minnie, if you want to give a little wave so you can stand out to the crowd here. And Minnie comes to us from Tukwila, and she was the deputy director there, and she served also the city of Federal Way. She's a very smart cookie and a very fast study. So like I said, we are so pleased to have her here, and I hope that you join me in welcoming her to our fine community in Issaquah.
Would you like to say anything?
Sure. Good evening, commissioners. I've been listening, and you are all have done your homework and have asked all the right questions and given us the right direction. I'm impressed by your thoughtfulness of, figuring out all the different options and then sorting through that. So we look forward to bringing back to you a good product after your input tonight. As far as me, I'm thrilled to be part of this community. I'll be reaching out to some of you and really trying to get a sense of how to work through the rest of the year. Any input you might have for us to get through. Some major updates coming your way as well. So hopefully we can not have these 3-hour meetings, and we'll try and get you the right information, but these are tangible, these are things that need some discussion and debate, and in the end, these will have lasting impacts on the community and the development that'll stay here for years. So appreciate everyone's time. I don't have anything more to add.
Well, thank you and very welcome. We're excited to have you. I'm going to call on Kristen to give us an update on the schedule.
Thank you. I apologize, I don't have it right in front of me. We are canceling the April 8th meeting, however. There are going to be too many of us out of town to give a presentation, which leads us to April 25th, which will be the public hearing on signs. The first meeting in May, we will be welcoming new members. We did interviews tonight. We will be welcoming some new members, and we will do election of officers that night as well. And you all have been asking to have discussions about the stormwater plan updates. So Gary Shinek, our new utilities engineer, will be coming and doing an introduction on the stormwater plan update for you all that day. That's all I have as far as the schedule goes. I would like to note that tonight is Joan Probola's last night with PPC. She has been here for many, many years, has served as chair several times, and has just done a fabulous job, has so much insight. She works here, she lives here, she's involved in the chamber, and it's just, we're just going to miss you, Joan. We really are. You've done a fabulous job, and Economic Vitality Commission, you have somebody really good coming your way. Take advantage of her knowledge and her humor, and just, we're jealous. So Joan, thank you for everything.
Well, thank you. I think it goes both ways. I mean, I've learned a lot and appreciated my time here, but I also want to give a shout out to the staff that has answered the questions, that have been forthright, especially Kristen. Kristen, she has done a fantastic job, so it's kind of a love between the two of us, and I hope that PPC uses her and keeps her on her toes and enjoys her updates and knowledge. So thank you. And with that, I'm also going to miss all the people that I met on PPC. So not going anywhere. I will see you. So I'm going to close the meeting, thank goodness, at 9:34, and wish you all I guess Easter's coming up. I hope you have a wonderful time with family and enjoy yourself. So thank you, and the meeting is adjourned.
Good night, everyone.
Good night.
Joan,
Good
you're a
night.
wonderful asset to
Good night.
PPC, and I think it's been a blessing having you on, and whoever's going to follow in your shoes, they're going to have some big shoes to fill.
Well, this is my last meeting, which